Good morning, everyone, and welcome to these, our third and fourth events in the Commission's series of Open Internet Roundtables. I wanted to take a quick moment to go over a couple of housekeeping items before we get started again this morning. First, you'll please note the location of the exits in case of an emergency. Secondly, we'll be breaking for lunch between 12:30 and 1:30 today, and there are some restaurant guides in the back of the Commission room. And finally, I wanted to note this event is being live streamed with open captions on fcc.gov/live. And for those viewing the live stream, you can submit your questions to roundtables@fcc.gov or using Twitter via the hashtag FCCRoundtables. Audience members in person can submit their questions on the cards that are being provided by FCC staff. We'll be collecting these throughout each panel. And with that, it's my pleasure to introduce Chairman Tom Wheeler.
Thank you, Eric, and thank you, everybody, for coming this morning, especially the panelists and the staff who have worked so diligently on putting this together. You don't have to turn around, folks. I'm going to be real quick. This is the second day of exploring the intricacies of the open internet. At the close of today, we will have had 12 hours of in-depth discussion by proponents of multiple positions. And there'll be more to come in October. We're webcasting this right now, so that it is available for all America to participate in. As Eric just said, and it's on the screen, here's how you can submit questions so that those out there in the networked world that we're all working to fight to protect here can have their opportunity to participate. I was here for the entirety of the discussion on Tuesday. I expect to be here all today. Commissioner O'Reilly is here today. I see Commissioner Rosenworcel just walked in. Commissioner Clyburn was here for the mobile session, introduced the mobile session on Tuesday. Commissioner O'Reilly, we began the session on Tuesday reading your thoughtful note. I used to bring notes like that from my mother, but I never had, to school, but I never had an excuse as good as the Kansas Broadband Commission. But we do appreciate your thoughtfulness in that. Like Tuesday, the goal of today is to figure out how do we turn heat into light. We're seeking dialogue. We're seeking thoughtful exchanges so that we can search for the equities in this complex issue. The challenge that we all collectively face in this is to discover solutions that represent the multiplicity of interests involved in this issue and the multiplicity of legitimate positions that exist. I would say to the participants that everyone has the right to retreat into their corner and continue stating their talking points. But there is a risk of missing the opportunity to help shape dealing with an issue that is not monochromatic. And so I encourage everybody on the sessions today and the ones in October to engage with each other, to have thoughtful exchanges, and to try and seek approaches that deal with all of the issues that this issue brings with it. A couple of process comments. I will recognize Commissioner O'Reilly and Commissioner Rosenworcel if either one of you wish to make opening comments here, okay? And then at the end of this session, we'll ask the moderators to create a window where any commissioner who is here has an opportunity to engage with the panel. With that, thank you to everybody, especially thank you to the panelists for being here. And Travis, we'll turn it over to you.
Thank you very much, Mr. Chairman. I also want to thank Commissioners Rosenworcel and O'Reilly for joining us here this morning. My name is Travis LeBlanc, Chief of the Federal Communications Commission's Enforcement Bureau, and with me today as my co-moderator is my Deputy Bureau Chief, Ms. Paula Blizzard. We would like to begin by welcoming everyone to the Federal Communications Commission and to our Open Internet Roundtable on effective enforcement of open Internet requirements. In particular, we would like to thank our distinguished panelists for being here today, along with all of the members of the public who are here in person or watching online. Effective enforcement is critical for whatever new rules the Commission adopts to protect the open Internet. Without enforcement, these rules are simply exhortations. And without effective enforcement, these rules may end up complicating or hindering our efforts to ensure that all comers, consumers, educational institutions, app developers, businesses of all sizes, and more can access the Internet on fair, just, and reasonable terms. Therefore, as the Commission's Open Internet Notice of Proposed Rulemaking, which sometimes we may refer to as an NPRM, states, we need to design a set of enforcement mechanisms for these rules that include at least three elements. First, there must be a mechanism to provide legal certainty so that broadband providers and users and edge providers alike can better plan their activities in light of clear Commission guidance. Second, there must be flexibility to consider the totality of the facts and environment of dynamic innovation. And third, there must be effective access to dispute resolutions by end users and edge providers alike. Regarding mechanisms of legal certainty, we regularly use enforcement tools like enforcement advisories, publication of enforcement actions, and the precedent of our past enforcement actions to provide greater legal certainty to consumers and the industry. Are there other tools that we should consider to ensure sufficient legal certitude or guidance? What other mechanisms might we at the FCC use to enforce the open Internet rules, given that the rules will be new and may refer to concepts such as commercially reasonable? Regarding flexibility, the Enforcement Bureau has built-in flexibility through its prosecutorial discretion and case-by-case adjudication. But are there other ways to ensure that whatever rules the Commission adopts leave room for flexibility in enforcement? And regarding access, how can we make sure that the Commission's complaint and dispute resolution procedures for open Internet complaints are accessible to all comers, consumers, startup edge providers, and ISPs, and even more? These fundamental questions of enforcement design are at the heart of this morning's Enforcement Roundtable. We will be examining these questions in two chunks, if you will. For the first half of the roundtable, we will explore what tools we can use to ensure certainty and flexibility in the Commission's open Internet enforcement, and what this means for the particular open Internet rule proposals under consideration. We will then break for 10 minutes at around 11:20 and return at 11:30 for the second half of our roundtable. During the second half, we will discuss how to design fair and accessible FCC dispute resolution processes for open Internet concerns, looking at proposals in the proposed rulemaking like alternative dispute resolution, multi-stakeholder processes, and an open internet ombudsperson. But let me be clear. This morning's roundtable concerns enforcement. While there are many issues that we could discuss about the open internet generally, Paula and I would like to keep our discussion centered on enforcement issues. But in doing so, I would like to remind our panelists and those who are listening near and afar about two of the central issues before the Commission in the proposed rulemaking. The first of those is whether to reclassify broadband internet access services as telecommunications services under Title II of the Communications Act, or whether instead to rely upon other sources of legal authority, such as Section 706 of the Communications Act. In the notice of proposed rulemaking, the Commission emphasized that both Title II and Section 706 are viable solutions, and that the goal of the proceeding is to find the best approach to protecting and promoting internet openness. As our discussion proceeds today, I ask our panelists to keep in mind that these legal authorities are on the table and to highlight in our discussion this morning where they believe that our enforcement authorities, tools, and options differ if the Commission ultimately decides to rely upon Title II or some other legal authority such as Section 706. The second important issue before the Commission in this proceeding is whether the same open internet rules that apply to wireline or fixed broadband should also apply equally to mobile broadband. As our discussion proceeds today, I ask our panelists to also please keep in mind that this fixed wireless issue is on the table and to highlight in our discussion this morning where they believe that our enforcement authorities, tools, or options should, if at all, differ for fixed or mobile broadband. To start out the morning, however, we have asked each of our panelists to give a 2-minute opening statement in which they address what they see as either the biggest enforcement challenge or the biggest enforcement priority for the open internet. Paula and I will then moderate a conversation among the panelists using both questions we have prepared and also questions we receive from the public via written emails, cards, and tweets. At the conclusion of the panel, we'll have another opportunity for additional questions from members of the public as well as any commissioners that are present. One important housekeeping note about questions from the audience, both those here in person and those watching online. By submitting a question, you are making a filing in an official FCC proceeding. All information you submit, including names, addresses, and other personal information, will be publicly available online. With that, I would like now to turn the microphone over to Paula, who will introduce the members of our panel and then ask them each to make a brief opening statement on our topic at hand.
Thank you very much, Travis. I'm very pleased to be introducing what I think is a stellar panel this morning. In keeping with the tradition, or dare I say rule, that was adopted on Tuesday, the panelists are seated in alphabetical order, and in fact I will also introduce them that way. So our first panelist is Rick Chesson. He's a Senior Vice President for Law and Regulatory Policy at the National Cable and Telecommunications Association. He's a veteran regulatory attorney who previously served in several roles at the FCC, including Chief of Staff and Senior Legal Advisor to several commissioners, Associate Bureau Chief for the Media Bureau, and Chair of the Digital Television Task Force. Mr. Chesson also has worked in private enterprise, including as Vice President for Policy at Respond TV. And he has practiced law at several firms, including Shepherd Mullen, where he was a partner. Next, Steve Curran is an attorney at Lerman Center in Washington, D.C. His practice focuses on the representation of fixed wireless broadband providers, equipment and technology companies, satellite companies, and wireless companies. Steve actively represents the Wireless Internet Service Providers Association before the FCC, Congress, and other federal agencies in matters involving spectrum policy, the Universal Service Fund, and other proceedings affecting wireless broadband service providers and other wireless technology interests. Next, we have Susan Crawford. She is the John A. Riley Visiting Professor in Intellectual Property at Harvard Law School, and co-director of the Berkman Center for Internet and Society. She's the author of a book entitled Captive Audience, The Telecom Industry and Monopoly Power in the New Gilded Age, and a contributor to Bloomberg View. Professor Crawford served as Special Assistant to President Obama for Science, Technology, and Innovation Policy, and co-led the FCC transition team between the Bush and Obama administrations. She also served as a member of Mayor Michael Bloomberg's Advisory Council on Technology and Innovation, and previously she was a partner at Wilmer, Cutler, and Pickering. I guess that was before it was Wilmer Hale, here in Washington. Next, Christine Hines is a Consumer and Civil Justice Counsel at Public Citizen in the Congress Watch Division. She advocates before Congress and the federal agencies on consumer protection and corporate accountability issues, including product safety and civil justice policy. Before joining Public Citizen, Christine was a writer and editor for various organizations covering international trade, intellectual property, food and drug law, personal injury, and the business of law. That's quite a lot of topics there, Christine. Next, we have Chris Riley. He's a senior policy engineer at Mozilla. He is working to advance the open web through public policy analysis and advocacy, strategic planning, coalition building, and community engagement. Previously, Chris worked as a program manager at the U.S. Department of State on Internet freedom, a policy counsel with the nonprofit organization Free Press, and was an attorney advisor here at the FCC. Next, we have McCall Rosen. She's Deputy General Counsel at Kickstarter, which is the leading funding platform for creative projects. She has served in that role since October 2012, advising the startup on intellectual property, contractual, employment, corporate governance, and regulatory matters, among others. Prior to joining Kickstarter, Ms. Rosen was at Paul Weiss in New York. And last, we have David Solomon. He's a partner at the Washington firm of Wilkinson Barker Nauer. He previously worked at the FCC as well for nearly 18 years, from 1987 to early 2005. He served as the first chief of the FCC's Enforcement Bureau under Chairman Bill Kennard and Michael Powell. Prior to that, he worked in the Office of General Counsel, including 5.5 years as Deputy General Counsel. And now I'd like to ask each panelist to make their opening statement. I'm sure you've seen the giant clock in front of you, that it will count down 3 minutes. We'll give you a little leeway, but if you go over too much, I'm afraid I'll have to interrupt you. Rick Chesson, I turn it over to you first.
Great. Well, thank you, Travis and Paula, for inviting me, and thank you, Mr. Chairman, Commissioners Rosenworcel and O'Reilly, for being here. We're here today to talk about the enforcement of potential open Internet rules. Let me just start by reiterating that the cable industry, as we said in our comments, believes in an open Internet, supports an open Internet. We did not appeal the 2010 rules, and we support the reinstitution of reasonable rules that protect consumers and protect against anti-competitive conduct. I think the goals of enforcement ought to reflect those goals and can be consistent with them. That is, they ought to be designed to prevent and sanction conduct that poses a real threat to Internet openness, while not unduly constraining the investment and innovation that has made the Internet ecosystem what it is. Over time, the FCC has adopted 3 basic ways of enforcing its rules. It has informal complaint processes, it has investigations, and it has formal complaint processes. And those processes have served the Commission well and resulted in significant enforcement across a range of issues. And I think that they will serve the Commission well in satisfying the goals that Travis laid out for open Internet of legal certainty, flexibility, and access to decision-making. I would add also a 4th important enforcement principle that they ought to pursue, and that's the principle of fairness. The FCC stands in a unique role when it comes to enforcement. They are not only the prosecutor, but they're also the judge. And having those dual roles, I think, makes it incumbent on the FCC to be particularly careful about its role in the process and to make sure that it maintains a neutrality and an even-handedness so that it can be a credible, issue credible decisions on the law and on the policy. I think that's very important for the FCC. I also want to stress the importance of the flexibility prong that you mentioned, which is why we're in favor of a case-by-case approach to Internet enforcement, as opposed to prophylactic prescriptive rules. We don't know which way this fast-moving Internet is going. We don't know how it's evolving. We don't know what it's going to look like 2 months from now, let alone 2 years from now. So it's important that the FCC's enforcement mechanism be able to take account of experience, account of situation as it changes, as facts arise, as business models change. And so I agree with what the Commission indicated in the NPRM that its approach would be, and I would just quote it briefly: as new circumstances exist, the Commission and interested parties will be advantaged by a culture of learning that draws on the strength of common law reasoning, reflects the experiences of the present as well as the logic of the past. And I think that that's the kind of approach the FCC ought to take here. That doesn't mean that you can't also combine that with clear guidance in ways, and find ways of providing guidance, whether it's through the order itself or through more informal processes. But I think that flexibility really ought to be the key here. And I'm appreciative that the FCC has recognized that balance between flexibility and certainty is an important one to draw in the NPRM. Thanks.
Thanks, Rick. Steve?
Well, good morning, and thanks to Travis, Paul, and your staff, and Chairman Wheeler and Commissioners Rosenworcel and O'Reilly for being here. I really appreciate it. As Paula mentioned, I represent the Wireless Internet Service Providers Association, WISPA, which is a trade association of more than 800 members dedicated to promoting fixed wireless broadband services. WISPs, as they are known, are small business owners in every state of the country. They rely primarily on unlicensed spectrum, once referred to as junk spectrum, to bring affordable broadband service to more than 3 million Americans, businesses, first responders, anchor institutions. In many remote and rural areas of this country, the only place where you can get terrestrial broadband is from a WISP, because it's just not cost effective for traditional wireline technologies to extend to these locations. So the Commission has acknowledged that most broadband providers are small businesses, and this is certainly true for WISPs. Many are mom-and-pop businesses with just a handful of employees. You may even see the owner climbing a tower to serve some farmers or families on the outskirts of town. There's no such thing as an average WISP because every network is different, but most of the 3,000 or so WISPs serve between 500 and 5,000 subscribers by making use of towers, water tanks, grain silos, utility poles, you name it. I should mention that WISPs are not Title II telecommunications providers that are eligible for federal subsidies, but they use their own money, and that from family, friends, and where they can get it a local bank financing. So in considering the future regulatory environment, and in particular the enforcement of open Internet requirements, the Commission should be mindful of 3 main points. First, requiring small businesses to comply with new transparency, reporting, and traffic management obligations will impose significant real costs and burdens on small broadband providers and their customers, the very folks who are least able to afford it and with no record of any bad behavior. That's why WISPA and others have asked the FCC to exempt small businesses from any new disclosure and reporting rules and from the formal complaint process. Second, we think the FCC should add certainty to an enforcement regime that today is entirely open-ended. In 2010, the FCC specifically refused to adopt safe harbors for reasonable network management. This created a vast gray area of enforcement risk that can be narrowed and combined with case-by-case adjudication to resolve questions that lie between those two lists or involve novel issues, as Rick said. Third, WISPA has proposed a specific enforcement process: good faith negotiation for 30 days before a complaint can be filed, a 1-year or less statute of limitations, a firm time period for commission resolution, and perhaps most importantly, a list of specific sanctions so that risk can be assessed and quantified and uncertainty can be mitigated. As Chairman Wheeler stated in his testimony before the House Committee on Small Business on Wednesday, and I quote, "Small businesses are a key driver of job creation and economic growth, and they are the foundation of local economies across America, from Missouri's countryside to the neighborhoods of Manhattan," close quote. So let's apply these same principles to small broadband providers by not saddling them with a one-size-fits-all regulatory approach that will increase cost, deter investment, stifle innovation, and slow the deployment of critically important broadband service to Americans that lack broadband today. Thank you.
Thank you very much. Susan?
Thank you to the FCC for having me here today. Thank you so much to the chairman and Commissioners Rosenworcel and O'Reilly for being here. I have no clients, no consulting arrangements, and I paid for my own travel down here. If you remember one thing from what I'm going to say today, it's this, that the best enforcement regime is a bright line rule based on very strong legal authority, which is only available under Title II of the Telecommunications Act. I want to commend the chairman for his September 4th speech, in which he made clear that when it comes to high-capacity Internet access, the vast majority of Americans have just one choice, and that's their local cable monopoly. And should Comcast and Time Warner Cable merge, that will mean that for 2/3 of Americans, their only choice will be their local cable monopoly called Comcast. On the mobile wireless side, we have a duopoly with a fringe at best. These four companies, Comcast, Time Warner Cable, Verizon, and AT&T, play the role of what some people call terminating monopolies. There's no way to get to their subscribers, if you have something to tell those subscribers, other than to go through their gates. And like Governor Chris Christie and the George Washington Bridge, it's quite possible to move the traffic cones on their side of the bridge, but invisibly, so we can't see what's going on, for any content providers trying to reach subscribers. So consumers are really collateral damage in some titanic battles between these terminating monopolies at the internet connection points and edge providers. Here, these companies are enormous, but the government is bigger. In fact, the government is the only entity that can take on these companies. They may have a profit motive, but the FCC acts under the public trust. The public trust trumps that profit motive every time. The only reason to water down very strong net neutrality rules under Title II would be to serve the commercial interest of the carriers. So the best possible enforcement regime here is a very clear, certain Title II-based net neutrality rule that takes into account both interconnection and last mile issues. Because any form of case-by-case, post hoc evaluation of a battle between an edge provider and one of these four titans will be a posthumous validation of the arguments made by the edge provider. Nobody can survive one of these tussles. The reason we've had no program carriage incidents at the FCC, no proceedings that have followed those rules, is that everybody knows it would be impossible to survive. So I look forward today to talking about crisp, bright-line rules that can make enforcement relatively easy, and about enforcing transparency for these networks using third-party engineers who can understand what's going on. Thanks very much.
Thank you, Susan. Christine?
Thank you to the FCC and its Enforcement Bureau for inviting me to participate on the panel today. I'm here for a very narrow reason to discuss the alternative dispute resolution issues, some of the issues that were raised in the proposed rule. And Public Citizen does not have a position on the larger policy issues of an open internet, but we are interested in the impact of the enforcement proposals that were in the proposed rule, and particularly related to mandatory arbitration that the rule included. And we specifically oppose pre-dispute mandatory binding arbitration. It's just a prevalent problem in the private sector, and particularly in the telecommunications industry with broadband providers, cell phone companies, and most other of the FCC regulated companies. But I'm interested, and I'm looking forward to talking about that issue today. Thank you.
Thank you, Christine. Chris?
Good morning. Thank you to Chairman Wheeler, to Commissioner O'Reilly, to Commissioner Rosenworcel, and thank you as well to Commissioner Pai and to Commissioner Clyburn, even though they are not able to make it. I know all of the commissioners are working very hard to serve the public on this issue and in others, and I wanted to express my appreciation. And as well to Travis and Paula and Stephen Ruckman back there, who helped organize this as well, even though he doesn't get to sit with us at this particular point in time. Mozilla's focus within the scope of this panel is on making sure that the rules are enforceable in a meaningful way. So there are two halves to that challenge. They've been teed up a little bit earlier, but let me just make those explicit. The first is a substantive one, making sure that the rules themselves are structured in a way that facilitates enforcement. The Commission has to hit the right level of abstraction with the language of the rules themselves to evolve with changing technologies and practices, while establishing enough clarity that practices that harm the open internet will be held to be violations, regardless of any future changes in Commission policy priorities. Some of the policy approaches that are on the table would make this much harder, particularly rules that are built on maintaining some form of good enough quality of service. It's impractical, if not impossible, for a small business who's being deprioritized in some fashion to prove to the FCC that the reason for the qualitatively bad service that's affecting their adoption rate is a quantitative failing of the network operator to meet a vague standard for good enough service. And for a new entrant, they might not survive long enough even to raise the complaint. The second half to the challenge is procedural. Even perfectly structured rules won't be enough to protect the open internet without effective and efficient mechanisms to resolve individual allegations of violations. As I think most of our panelists would agree, the base of such mechanisms is already present within the current operations and processes and the flexible framework that the Enforcement Bureau has and the range of options available to it. But we believe there are ways to expand on that, to talk about enforcement mechanisms in more detail, both today and after a final order is adopted. We don't have to get all of these things figured out by the time rules are adopted and move forward. The goal, of course, is to provide certainty to network operators, to developers, and to internet users, and it's not an easy thing to do. But we believe there may be opportunities to help all of the stakeholders in the internet's ecosystem contribute to discussions of the benefits and the harms of network management practices today and in the future by continuing and expanding on the work of some of the groups we have, like BTAG and the Open Internet Advisory Council, and through others. The final thought I want to raise at this point is that the Commission's chosen path forward on authority matters in this conversation, as it does in every other. Susan made these points better than I could, so I just wanted to emphasize my agreement with this. We can't have clear standards, we can't have clear rules without building them on Title II. Without that, I believe the Commission will be forced to inject vagueness and exceptions into its rules to increase their chances of surviving court review by distinguishing their actions from common carrier. And the result is not only a greater risk of permitting harmful practices, but also greater difficulty in effective enforcement of the rules.
Thank you, Chris. McCall?
Good morning, and thank you to Paula and Travis and to the commissioners, and as well to Chairman Wheeler. For those of you not familiar with Kickstarter, we're the world's largest funding platform for creative projects. There have been hundreds of thousands of innovators, entrepreneurs, artists, creators who've turned to Kickstarter to bring their creative ideas to life. There are also millions of people who've come onto the site to back projects in order to support people's dreams. The fight for the open internet is not just about companies like Netflix or Google. It's about smaller companies and startups from all over the country and in every field, fields like e-commerce, social media, and crowdfunding. And it's about the entrepreneurs and artists who turn to sites like ours to turn a spark of an idea into a film or into the Pebble Watch. We're the people and the companies who rely on a level playing field in order to reach consumers and to prove ourselves on the basis of what we're offering, the quality of what we're offering. And unlike the carriers or even companies like Netflix, we don't have billions or even millions of dollars and hundreds of lawyers to devote to just making sure that we can get our product out there. For a startup, Kickstarter is actually kind of large. We're a little over 90 people, but I'm the only lawyer. And hopefully no one sues us today because I won't be able to deal with it because I'm here with you guys. But as our lawyer, I deal with things like ECPA, I deal with things like DMCA and trademark and privacy and our international expansions. Luckily for me, I've never had to think about FCC rules or regulations until this proposed rule came out. And I've never had to spend time negotiating deals with all of the ISPs out there. This is all just to say that even contemplating rules like those proposed in the NPRM is a huge burden on our business and on any startup. If the rules as proposed were passed, the burden would be overwhelming for us, for other startups, and for the companies that don't exist yet and that are just trying to get off the ground. If our founders, before founding Kickstarter, had to figure out how to negotiate access fees with ISPs or to allocate money for prioritized access, it's really doubtful we would have the product that we have today, and their ability to raise money from investors at all would really be compromised. So the way we see it is that we have two very clear choices here. We have Section 706 on one hand. Section 706 creates a muddled regime full of uncertainty, no realistic remedy or enforcement mechanism as we see it. Not only is the enforcement regime that envisions years of regulatory dispute resolution to determine what's commercially reasonable, an uncertain prospect for a company like ours, but it's also just useless for us because our ability, as Susan and Chris noted, to fight these things would come after they've already killed us, essentially. It's not feasible for a company like Kickstarter to devote the necessary resources to go up against the carrier's army of lawyers. On the other hand, we have Title II. Title II would allow the FCC to create clear and simple rules that allow for similarly clear and predictable enforcement mechanisms. If we have bright line rules against discrimination, against blocking, and against access fees, Kickstarter, companies like us, would know exactly what to expect. We would be able to act quickly without following a complicated multi-factor regulatory process and achieve a remedy if we just on the basis of seeing that the carriers are violating the rules. This is the type of certainty that allows and fosters true innovation, and it permits small businesses like ours that are the real drivers of jobs and of the economy to flourish. Thank you.
Thank you very much. And finally, David.
Well, as the last speaker, I've figured out a way to assure the chairman that we've already brought consensus to the whole group, which is I, too, thank the chairman and the commissioners and Travis for holding this session and for inviting me. I think the commission is to be commended for thinking seriously about enforcement while it's thinking about the rules rather than waiting till after the fact. I think the commission had a lot of thoughtful ideas in the NPRM about how to think about enforcement, and it's particularly important in the open internet because in the open internet context, because the internet is so important and so dynamic and changing that the commission think about enforcement before adopting any rules. I think the key open internet enforcement challenging the commission as it thinks about the rules is to avoid unintended consequences that would chill investment and particularly innovation as well by entities subject to the rules. Everyone recognizes the internet is a unique, incredibly dynamic technology that is evolving continually. No one can really imagine what it's going to look like a few years from now, let alone in 10 or 20 years. It's really important, I think, that the FCC carefully calibrate its enforcement so that it's addressing real harm to consumers when it takes enforcement action. Because if it doesn't do that, there's a real risk that enforcement could seriously hurt development of the internet and the interest in consumers and edge providers alike, who themselves benefit by the kinds of innovation and creative offerings that ISPs can offer. There are a number of ways I think the Commission can think about its enforcement regime in a way that certainly takes the rules seriously, but at the same time balances that with the importance of not deterring important innovation and creativity. First, I think the Commission can establish safe harbors and rebuttable presumptions up front that will help lower the risk of innovation so that the people subject to the rules will understand that certain types of creative things that they may not be thinking about right now, but they may think about in the future, are okay from the Commission's perspective. Second, I think the Commission should encourage the informal resolution of open internet disputes resolutions through a variety of mechanisms that I think we can talk about more this morning, but direct negotiation, independent technical bodies such as BTAG and others giving advice, multi-stakeholder processes, FCC-sponsored mediation, and other similar concepts. When FCC action is needed, I think a good place to start is the declaratory ruling process. I think there's a lot of policy and technical expertise in various bureaus and offices around the Commission, and to the extent that the resources can be devoted to the issue so that when disputes arise, the Commission can give binding authoritative advice after a full consideration on the record that says, okay, here's the issue, we've had input from a variety of stakeholders, and here's our answer, and then people know the answer. And historically, the problem with the declaratory ruling process has been that it moves too slowly. So sometimes things like task forces and strike forces are popular, and to the extent the Commission may have a declaratory ruling strike force in this area, I think that would be productive. When proceedings do get to the Enforcement Bureau, I agree wholeheartedly with the statement in the NPRM that there must be flexibility to consider the totality of the facts in an environment of dynamic innovation. I think it's important that the FCC focus its enforcement on providing guidance and not necessarily being punitive in the first instance. This is best done, as the NPRM indicated, I think, through a case-by-case basis with full opportunity for the parties whose practices are being challenged to explain why they think that they're valid. As the original Open Internet order indicated, the Commission in that process should get input from the other bureaus and offices, in addition to the Enforcement Bureau, that have policy and technical expertise in the area. And again, before taking enforcement action, I think the Commission should ensure there's real harm to consumers, and that any such harm is not outweighed by the benefits to consumers that might be lost through deterring innovation. Thanks.
Thank you very much.
So we have a panel representing diverse interests, organizations, and viewpoints today, and I know we're going to have a lively discussion. I'm going to jump right into sort of the first framing topic that I mentioned earlier, which was providing mechanisms that bring about greater legal certainty. And to all the panelists, please feel free to jump in at any time once the question is on the table. The first question I want to ask is, as the Enforcement Bureau, we enforce virtually all the provisions of the Communications Act as well as the FCC's rules, regulations, and orders. And from an enforcement perspective, why might enforcing open internet rules present different challenges from all those other provisions that we enforce? As a number of you have already mentioned, we have the ability already to conduct investigations on a case-by-case basis, to assess monetary forfeitures, to mediate complaints, settle complaints. What's different about enforcing open internet rules? Are those tools not sufficient? Do we need any other enforcement tools than we already have? And David, as a former Enforcement Bureau chief, what do you think about this challenge?
So my reaction is that the existing tools work well. As Rick mentioned, the Commission has had no problem having very high enforcement actions against companies that violate its rules. I think if you go through each of them, they all work differently, but the informal complaint process for consumers, I think, is a good avenue for consumers to get their views across to the Commission. The Enforcement Bureau's Telecommunications Consumers Division has historically tracked all of those complaints that come into the Consumer Bureau very carefully and uses them to guide its investigation. So I think it's a good way for the Commission to have a pulse on what issues are arising, and I think that's appropriate to look at sort of complaints as a group, not necessarily individual consumer complaints. The FTC, which I think is well recognized as sort of the government's consumer enforcement experts, they have a database that collects complaints, and they use those complaints to guide their investigations. So I think if the Enforcement Bureau is tracking those complaints and sees that there are trends, whether it's a particular issue or a particular company, that's a good basis for it to take action. And at the same time, it's a very inexpensive process for consumers. There's an analogous process for companies that are concerned, and I recognize some may be small companies that don't have the resources, as was described, to hire lots of lawyers to bring a complaint. The Investigations and Hearings Division historically, and other divisions in the Enforcement Bureau, has always been open to letters, emails, et cetera, that say, I'm a competitor, I've got a problem, let me describe it to you, here's why I think you should start an investigation. And again, that can be a fairly inexpensive process for the people who are bringing the matter to the Commission's attention, but at the same time, the Enforcement Bureau, if it decides it's a concern, has appropriate resources to look into it and has demonstrated it can take strong action. And then in circumstances where there really are kind of major disputes between companies, the formal complaint process can work. And there's also, I've just finished by the mediation process that the Market Disputes Resolution Division uses. The Commission said in its original open Internet order that would be available, and that's often a very effective and inexpensive process for companies to help them get disputes resolved.
Susan, I think you wanted to jump in?
I think what makes this set of problems particularly difficult and interesting for the Enforcement Division is two things. One, the scale, and second, the crushing information asymmetries under which you operate. That engineers can reverse engineer what's happening at the interconnection points between these terminating monopolies and other networks. We can sort of see what's going on, how packets are getting their kneecaps broken as they try to get to subscribers. But inside the networks, in the last mile, no visibility. And for example, in the cable last mile, all of their bandwidth is being dynamically allocated between their own video, their own voice services, their own on-net data, like StreamPix, for example, in the case of Comcast, and then the best efforts internet kind of limps along underneath that. We can't see that. You don't know what's happening inside those networks. And you would need to have real visibility there. You'd have to make sure that there are engineers who are able to understand what's happening dynamically across those networks in order to realistically enforce bright line, last mile net neutrality rules. You should have that authority. That's your role, but this set of problems in terms of your audit function is more difficult than things like USF and other areas of your operation.
Let me just respond to a couple things that I've heard. First of all, I think what Susan just said should be frightening to people who worry about heavy-handed regulation. All of a sudden, we're talking about not only Title II, but actually monitoring how the plant is used in the last mile. And she also talks about being kneecapped at the interconnection points, when in fact it's been shown that the content providers also have tremendous control over how content gets routed to through different pathways on the internet. So if she's talking about maybe expanding it so that we have visibility into all that, I don't think she is. It's only seems to be about one side of the equation. That sort of goes to what I was talking to about an even-handed approach. I also did want to quickly talk about some of the Title II stuff I heard, because I think that there's some real myths that I heard the first time around on the panel. The first myth is that there's anything clear and bright line about Title II. I think anybody who's ever worked in Title II and is watching online or something wonders what Title II are they talking about. I think they said that Title II has bright line rules against discrimination. Well, the very clear language of Title II only prohibits unreasonable discrimination and only compels reasonable rates, terms, and conditions. There's nothing clear and simple or quick about Title II. Title II, anybody who's participated, for instance, in the special access rulemaking, it's been going on for over a decade now with no resolution about what special access rates should be. There's nothing quick, nothing simple about Title II. It's really ill-equipped for dealing, in fact, with this kind of quick-moving marketplace. In 2010, when the FCC looked at this and was deciding between a Section 208 enforcement regime and another one for Section 706, it specifically said we're not adopting Title II because that enforcement regime is way too onerous for the parties. It requires you to file all sorts of things with your pleadings. If you're worried about having not enough resources, you file a Title II complaint or Title II answer. You have to attach every potential document that you're going to rely on. There's a whole list of things that would make your head spin. So the idea that there's something easy and quick about Title II, and I'm not even going to mention all of the problems with going to Title II, because that's not what this panel is about. But just from an enforcement point of view, there's nothing simple, nothing quick, nothing easy about Title II.
Let me ask a question. Rick, you've just told us about the burden of striving for legal certainty. But let's look at the other side. Let's talk about what happens when there's legal uncertainty. Steve, maybe you have some thoughts on that for us.
Legal uncertainty. We took a look at the 2010 order, and the Commission specifically said, we're not going to adopt any safe harbors, and we're not going to adopt any specific remedies if you're found to be violating these rules. And my first reaction is the same one I have today, and that is you've created a sort of vast gray area where it's very difficult to quantify the risk and assess the risk. And if you're a small ISP and you're looking for money and a banker says, I see you have this net neutrality complaint, tell me what that means. And I can't sit there and say it's a $1 problem or a $1 million problem or it's a slap on the wrist or it means nothing, because we haven't had any case-by-case adjudication and we don't have any real parameters. So what we'd like to see is let's establish some rebuttable presumptions of things that are commercially unreasonable, and let's establish some safe harbors, and let's take that gray area and let's narrow it down and supplement that with case-by-case adjudication, because as we've all said and we all know, the internet is dynamic, it's evolving. You can't draft rules that are going to anticipate every change in network, every new network management practice, what have you. So I think when you start looking at certainty and flexibility, and as I think all of us have said, and as the Commission has obviously acknowledged, a lot of this proceeding is about balancing flexibility and certainty. And in some places there may be too much flexibility that's proposed, and in some places there's too much certainty that might be imposed because it would constrain behavior. So I think that's kind of where we see it. And if you want to put the small business angle on it, if a small business is looking at something like this, these are folks who, every nickel matters. And if they get involved in a Title II or a formal complaint proceeding, and under Title II they'd be subject to damages, that's a whole different ballgame. And that also, could fuel the plaintiff's bar to go out and find folks and, round them up and say, let's go after these guys. And if you don't have any safeguards built in on the front end, that's a very scary proposition for a lot of small businesses.
We have a question from the internet. Someone emailed us and says, this is Brett G. in Laramie, Wyoming. Does someone here know Brett? A few people seem to know Brett. Just from Twitter, okay. Brett, the panelists are excited by your question. I haven't read it yet. Small and competitive ISPs are least able to afford the legal assistance required to deal with heavy paperwork requirements or potentially frivolous complaints. How do we prevent costly rules or case-by-case enforcement of vague rules from driving these vital competitors from business?
I think I sort of answered the question, so maybe you guys want to pile on.
Sure. I certainly agree that sometimes when people think about ISPs, they think about just about the big ones, but there are 2,000 ISPs in this country, many of which are small businesses, most of which are small businesses. And so as we're talking about relief for smaller entities here, we have to be, I think, also sensitive to the need for their relief and the potential burdens that they have in responding to complaints that may, as this questioner said, may be frivolous often.
So, Steve, you mentioned the idea of safe harbors and ways that people would know what type of potential trouble they were in and some certainty, and so they'd have a better sense of that. Those are not in the rules right now as a proposal. What, and I put this to you or to other members, how would the Enforcement Bureau go about developing those? In other words, one person's safe harbor is another person's disaster. And I think given the timeliness, we've also discovered if we go through an entire another rulemaking, that may not help either. So what are some suggestions on that? And Chris Riley, I think you have some thoughts?
Yes, I would like to jump in on this point. I think this is an area where we really can work pretty well together. But again, I think this comes after the rules. I think the rules already have built into them a very strong mechanism for this. It's the reasonable network management exception. It's designed to allow for behaviors that are considered to be reasonable network management. So I was actually really glad to see this iteration of this very long process. In the record, we started to see some very technical statements from CTIA, from the wireless industry in particular, of load balancing algorithms and scheduling algorithms and the advanced things that they do in their networks to make them work. I love seeing that. That's what we should be talking about. Let's talk and make sure that they know that they have the capacity to do load balancing, to do scheduling, and let's get into the technical here. And it's not always easy to do that. But we do have BTAG. We do have outside technical advisory groups that have different interests there, that have a mix of perspectives and opinions that can help get the normative balance right, and can then feed that into the Enforcement Bureau and have it reviewed and approved and adopted through some form of declaratory ruling or advisory opinion. And if I may very quickly, on Title II, moving to Title II doesn't take informal complaints off the table. It doesn't mean that everything that happens suddenly becomes a formal complaint process. So I very much don't believe that makes life significantly more difficult, especially if the Commission does what many are asking them to do, which is not merely move to Title II, but move to Title II and then adopt very clear rules based on the authority of Title II. That means that the precedential uncertainty that some point to in the history of Title II can be clarified much more directly through clear rules.
Christine, looks like you have something to add.
Yes. So I think that that we might be coming from a wrong place. Meaning that if we're going to assume that complaints are frivolous, then I think that's the wrong place to start, because this is about enforcement. Enforcement generally means that it's enforcement of somebody violating the rules. So assuming that the complaints are frivolous from the outset is unhealthy. And so what we're trying to do is to set up an open, fair, transparent, at least that's what public citizen would want, open, fair, and transparent, and a system that will provide, choice for consumers in filing complaints and getting their complaints heard. Just assuming that that complaints are silly from the get-go is not a good place to start.
David?
Can I just make a point about complaints? And I certainly don't disagree that one should. I agree with you. One shouldn't assume every complaint that's filed is frivolous. The Commission should look at complaints carefully and take them seriously. But I think going back to a point that Rick made in his introduction about the fairness aspect, it's also very important not to assume that when a complaint is filed that it's valid and that it shows that there's a violation, and that the Commission's role, I think, has to be a very objective one. And Rick's point about there's a real has a balance between the Commission's prosecutorial function and its judicial function. And just as an aside, we thought a lot about this when I was at the Enforcement Bureau, and we started with a motto that said, and we made this public, that we were going to be firm, fast, and flexible. And we talked about we needed to be tough and we needed to be fast, et cetera. And pretty soon after that, we changed our motto and we said firm, fast, flexible, and fair, because we realized that it really was a tough issue, sort of balancing the fact that part of our job was to say we need if there are violations, we need to investigate them and take appropriate action, but at the same time not be in the mode of saying our job is to see if we can plausibly build a case against somebody, and if we have a plausible case, then our job is to go with it. The job is to think objectively about it. Unfortunately, that was, given some later things that happened, coming up with F words for our motto was a real mistake as indecency enforcement became a big issue, but that's a separate matter.
Let me add to that, because in my private practice, I've had to deal with a couple of informal complaints along the way from private citizens who complain about interference or some such thing. And oftentimes it's a case of they just didn't know, or they were confused, or they didn't understand what the rules were to begin with. And those are the sorts of things, if you set aside that that maybe there's some disgruntled employee involved and you accept it at face value, that those are the sorts of things that you may be able to work out. You call up the ISP and you say, hey, I've been experiencing some congestion on my network for the last week. Thought I'd bring it to your attention. Can you tell me what's going on? And the ISP says, yeah, you're right. Maybe in a fixed wireless scenario where you're using unlicensed spectrum, there was a tree that popped up, or maybe they bought 3 more devices and, all of his kids are downloading Netflix at the same time, or, a variety of, a new building came up, or something that prevents line of sight, or what have you, that could lead to congestion or degradation of service that the ISP may not have known about. And I think through some sort of pre-filing mandatory process, you can eliminate a lot of those. You can lead to private resolution before you even end up at the doors of 445 12th Street. And to my way of thinking, if you can eliminate the involvement of a third stakeholder, in this case the Commission, and reduce it to the private relationship that exists between the ISP and the customer, then you can eliminate a lot of the time, expense, and burdens associated with what might be a very scary enforcement process.
Nicole?
I think when we're talking here about the complications in enforcement and making sure that we can weed out complaints that are frivolous, this is precisely why having bright line rules is so important and would be so valuable. If we have a bright line rule against application-based discrimination and our engineers as an edge provider can point to a degradation in service, then the burden would be on the perhaps we could turn to the ISP, and unless they can show that it's resolved if we restart our router, then the presumption is that they're violating these bright line rules. And back to the question of small businesses and making sure that the rules protect small businesses, it seems a little strange to me that we're talking about small businesses in the context of carriers and ISPs, because I think everyone out there knows that there may be 2,000 providers out there, but for all intents and purposes, there are 3 or 4 for almost everyone in this country. And the real small businesses that have their existence at stake here are the edge providers, as well as some consumers who are trying to run small businesses through a consumer connection. And so what we need to make sure is that these edge providers do not have to answer to the big 4 gatekeepers in order just to get out there. And when we're talking about why existing mechanisms of enforcement wouldn't work here, I think the language that David used shows why the internet is so different. This isn't a situation where a company brings a complaint to the FCC and says our competitor might be doing something against the rules here. Can you look into it? The imbalance of power here is so enormous that our ability to even exist is based on these rules and based on the ability to have strong, bright line rules.
Susan?
Just very briefly. So, Paul, you've asked about safe harbors. The Nixon White House didn't want to regulate, but said what we should really do is structurally separate. You're either content or conduit. That's the simplest thing. So we're on a kind of a sliding scale. The next step down would be to look very hard at interconnection and say that's where enforcement is required. And there we're going to say that these terminating monopolies have an obligation to provide an uncongested path to subscribers. And if it's going to cost $800 to put in a router, we'll share the cost of that router between connecting networks and the terminating monopolies. That's a little bit more difficult than structural separation, but not too much. And then you get down into the next more difficult form of enforcement, safe harbor, would be reasonable network management, as Chris has suggested, and having a technical definition of that that gets out, that doesn't permit commercial discrimination to be part of reasonable network management, but rather is done for technical load balancing reasons. So you've got a scale here. You can choose to start on the simplest version of this, but it all depends on the rule. And the reason we're talking about Title II is not that it's simple to create the rule necessarily in Title II, but at least you're standing on firm legal ground. That's the problem with walking away from Title II. Thanks.
Chris?
I want to take a moment to point out what I believe to be a very positive recent development in this back and forth and in these exchanges. So how does this work in the real world in practice? If I'm sitting at home and I'm using my internet connection and I'm noticing something that seems like it's a service disruption or a targeted service disruption or a site or two that doesn't work, what do? I go into Twitter. I talk about it. My friends see it. They check it out. If a few of us all using the same network operator find the same thing, we'll all tweet about it. And then you know what happens magically? Comcast Cares responds. They look into it. And this is the most amazing mechanism or structure for informal exchanges back and forth that we could have. We didn't need to do anything for it. So I don't have like a specific ask, and I'm not sure exactly how that fits into this. But I just wanted to point out that that's happening. It's a good thing. We can encourage it. If we do do end up with an FCC ombudsperson, I would hope they would live on Twitter and Facebook and watch for people tweeting at ISPs just to gain this awareness and this understanding and get a head start. At the other end of the extreme, of course, formal complaints, I just wanted to make the point that although they are certainly, I'm sure, very difficult and expensive for ISPs to receive and field and process them, they're also very expensive to file. Free Press, my former employer, went through quite a lot of resources and effort and money in order to do what they did. So it's not something that will be done lightly by the people filing it either. I mean, it's there when you've already had people going to Twitter and complaining, and they've already pressed on it, and they haven't been able to get a resolution through other ways. So it's really essential to have that as the last stage of this process when other efforts don't work.
Thank you, Chris. I've now learned when I have an internet problem that I should go right to Twitter.
Absolutely.
I didn't know that before. Rick,
Can I just say
sure.
one thing? On the, I think somebody made the point that the bright line rules are necessary for a company like Kickstarter to survive. I think the proof is somewhat in the pudding there. You know, we had no rules up until 2010, and then we had a case-by-case analysis from 2010 to 2014, and then again we've had no rules on the books since then. And Kickstarter, I think, has done very well in that environment without having what you say is the necessity for some sort of bright line rules, which I don't think could ever be really bright line, and have all the downsides of taking yourself out of being able to account for the evolution of things. On Susan's point about Title II being firm legal ground, of course, we could go on for days about that, and we disagree strongly about whether it's a firm legal ground to try to reverse the precedent at this point. Just pointing out that the court said 706 gave the FCC the authority it needed to adopt the internet rules that it did. I would also say that this sort of, again, the way Susan's playing it out here, and with all the talk about terminating monopolies and things like that, it leads me to believe that the whole idea of forbearance, which is something that will come up as a part of the enforcement process, which rules of Title II would you be enforcing, it backs up, I think, our concern that this is not going to be an easy, quick process. As you hear people, Free Press, public knowledge, some of the comments, Susan's comments, you have to find in order to forbear that the marketplace will adequately protect consumers. So people who think that that is going to be the panacea to a heavy-handed Title II approach, I think are really mistaken. We're going to have it be a long, drawn-out struggle that could go on for years about which aspects of Title II actually apply.
McCall?
It is true that Kickstarter was able to be founded and to thrive, as well as any number of startups, and that's because we've been operating under de facto open internet without rules. Essentially, the carriers have been afraid that they would be somehow punished if they discriminated or blocked. And now what we're facing is a situation where either the FCC codifies that open internet or gives a rubber stamp to discrimination and to the access fees and to blocking that the carriers, until now, more or less, have refrained from doing. And in terms of the cost under Title II versus 706, it's true that filing under Title II would take up a lot of resources, would not be an easy process, but what we have there is a system where once we file and we've done our research and we know we have a basis for filing, then we can have a remedy. We can have an injunction. We can have possibly fines, though I think injunctive relief is really more of what we're looking for. Under 706, it's not just the filing. We're guaranteed to go then into years of litigation and through the regulatory process and then through the appellate process, getting experts, getting discovery, just to try to prove this vague standard of commercially unreasonable. And so under any way you look at it, 706 is a far more burdensome regime than Title II.
So I know you want to respond, Rick, and there will be time as the day goes on. We do want to make sure we get through all of our topics, and we do want to make sure everyone gets heard. The rule talks about a couple of ways that the Enforcement Bureau or the FCC could put forward some more guidance, whether that be describing safe harbors or remedies or simply describing what has been found to be commercially reasonable or not, ways that we could give more guidance to the industry. A couple of those are called business review letters. This is what the Antitrust Division does. Before undertaking conduct. Sometimes two companies will ask the Department of Justice to give a statement of their present enforcement intentions, which means whether they think it will violate the law, in essence, ahead of time. The FTC does advisory opinions, sometimes at the commission level, sometimes at the staff level, again, giving an advisory opinion about what might happen to provide guidance. In the Enforcement Bureau now, we put out enforcement advisories. So what I'd like to ask to the panel is whether you think we should adopt some of these other processes, such as business review letters or advisory opinions, and whether that will help give some guidance on these questions or whether they're not necessary. And Susan's looking like she wants to answer, so Susan?
Well, I'm thinking about when the FTC, for example, takes on a consumer protection online matter, I think they think of themselves as talking to lawyers. That what they're trying to do is take on an enforcement action that would carry with it real sanctions, real penalties, and make an example out of a company so that everybody else watches. Whatever form your actions take, they need to have that warning, signaling function to the rest of the industry. And if it's letters, that's a way to do it. If advisory opinions make me more uncomfortable because then there's a sort of a permission-based world for the carriers that may have real unanticipated consequences for everybody else. The carriers are really just carriers. They're just sidewalks. And it's just bandwidth. That's all they're doing. The innovators are the 300 million Americans and the edge providers and everybody else. And the carriers will say, well, we need to innovate, just look at us later. And then it's going to be very difficult for the commission to unscramble the egg after they've actually done whatever it is they're going to do to edge providers and consumers. So bottom line, whatever you do should take the form of really strong enforcement actions that have a signaling function for the rest of the industry that represents the carriers.
Okay. Steve, do you have a reaction to that?
Let me pick on one, and that is, or maybe two, and that is staff opinions that would be, I think, under what the commission asked for comment on, be non-binding. And so I asked myself, I said, well, if it's non-binding, then the first thing someone's going to do is they're going to point to that and they're going to say, well, gee, I did just what that is, but now you're telling me it's non-binding, so I can't rely on it. And then the next case that comes along is going to be a little bit different. And so you're going to look to that and you're going to say, well, I'm a little bit different and it's non-binding. So I asked myself rhetorically, what is sort of the value of it? Maybe there's some thought piece that could make some sense, but in terms of a non-binding staff opinion, not seeing it. The other thing I wanted to comment on is an enforcement advisory. In July, the commission put out an enforcement advisory. It says, folks out there, speed test your ISP and come to us, and here's how you file a complaint. And again, I don't want to sound like a broken iPod. I would say broken record, but there's a lot of folks out there that don't know what a record is. But, it sort of hit me the wrong way that it was not collaborative and cooperative. It created an adversarial type approach to that sort of thing. So I think if there's an enforcement advisory, there maybe should be some record behind it. It should, encourage collaboration and cooperation rather than a process that looked like that commission was trying to build a record to support transparency rules. So that was sort of my take on it.
I want to underscore something about what Steve was saying. I mean, the enforcement advisory process, I think, can be very helpful if it's sort of reminding people of what the law is and getting the word out of what the law is and telling people that there could be substantial consequences if they violate the law. But I don't think it's a very good mechanism to try to evolve the law or change the law, which I think some people feel is what the more recent one about the Open Internet Transparency Rules was doing. That I think even though it may be more resource intensive, if the commission sort of wants to have the law and evolve in a particular way as a policy matter, it's much more effective to have a proceeding, a declaratory ruling proceeding, for example, where people comment, there's a record, either side can appeal. It sort of puts you not only in a difficult position in terms of providing advice, but also in terms of procedures. So the commission issues an enforcement advisory. do you file for reconsideration, or if you do, does the Enforcement Bureau say, well, it wasn't an action, so you can't file for reconsideration? It's just sort of not clear how you challenge that. And going back to what said at the beginning, not to sound like a broken iPad, but I really think that when the Commission sort of prospectively wants to give guidance, it's really helpful to do that through a record proceeding. Whether it's a declaratory ruling or if something's been brought to the Commission in a complaint, it still may be helpful rather than saying, okay, we find whatever the standard is, whether we find this isn't commercially reasonable or there's some other standard, that the Commission says, so prospectively now this is what people need to do, as opposed to saying, now we're going to punish you for the fact that you may have had a certain decision to what you thought was helping your consumers to have a certain offering, and now the Commission's deciding, no, on balance, that's anti-consumer. That should be prospective advice, not sort of retrospective punishment.
Let me just follow up to David. By a record proceeding, are you suggesting that there be notice and comment in that proceeding before a decision was made, or are you suggesting that there be some kind of notice and comment afterwards with a possibility to revise?
No, I think before. I think if the Commission's thinking generically about giving sort of policy advice and evolving the law, kind of the right way to do that is through a proceeding. Obviously, if it's faced with a formal complaint, that's a proceeding and it has a small number of parties, but nevertheless, there's at least people on both sides of the dispute, so that going back to what Rick said about the multiple functions, that the Commission is then deciding that sort of based on a record that's before it.
Point of personal privilege.
Rick first, then Chris.
I think my industry was called a sidewalk, and I just want to say something about it. Sidewalks don't have to, increase capacity, double every 18 to 24 months like ours has done. The ISP industry was the investment heroes, a leading industry in investing in infrastructure in 2014. If you're looking about the magic and where the innovation has to happen, I would argue that building a platform, look at Netflix, they went from a mail order company to being able to provide HD video over the internet on demand. That's because of the platform. It's not just a sidewalk. Sidewalks don't grow and change and have to adapt to hugely changing consumer needs as much as the internet does. So I think that's at the very least a mischaracterization of what it is.
We'll go quickly to Chris.
I just wanted to say I respect the comments about a record proceeding and the arguments behind that, but let's not forget that record proceedings, whether processing complaints, notice and comment rulemakings, no matter any form they take a very long time, and they're very complicated politically and legally, and there's a real risk there that unless we start, it's a risk that developers and internet users who are suffering from harm will take too long to get that remedied. It's a risk that is made better if we start at the beginning with very clear rules. That helps a bit, but things change over time, and we need to have more ways to respond flexibly than having a political rulemaking proceeding as things change and evolve for every step along the way.
Just very, very briefly, this reminds me of a cartoon I saw recently where there's a tiger chasing a bunny rabbit, and the tiger says, but it's a level playing field. And when it comes to enforcement actions that take the form of public record proceedings, that's Chris's point, that it actually isn't a level playing field for the much smaller actors who have almost no power in this setting.
Right. Given that the timing of this part of our panel is coming to an end, I want to make sure to stop right now, offer time to any of the commissioners, the chairman, who may have any questions right now, as well as if we have any from the public. And seeing none right now.
Wait, there's a chairman? There's a chairman.
Jessica, you okay? Well.
There you go.
So there has been a discussion here about the tension that exists between a case-by-case approach, which has flexibility, but that's offset by cost and time, or a bright line approach, which is the tension between something that's clear cut, but it's less flexible. There was a proposal that was put forth yesterday by Congresswoman Eshoo that said, hey, there are 47 parts of Title II. The only one that really you need to deal with here is Section 202. Anybody want to comment on that?
I haven't reviewed that, but that is pretty interesting. I mean, in our filings, we have said we have a slightly different approach of getting to Title II, as many in this room already know. But we share the belief that, at minimum, our ask was for 201, 202, and 208 to reserve that possibility of a formal complaint. To get it on the record, as McCall said, to make sure that we can get to a resolution. I mean, I think that's enough, and that helps a lot. Going down just to 202 is something I'm going to have to go look and think about. That's pretty interesting, but I'd like to have that backstop of 208 and Title II formal complaints as part of this to provide additional surety. I'm not sure how I feel about losing that.
First of all, it carries two risks. One is that you would be able to forbear and get down to just that, and I would note that some of the commenters in the record, such as Public Knowledge, found, I think, three provisions of Title II that they'd be willing to forbear from. So I think that I would anticipate a major battle that could last for quite a while and go to court about exactly what the FCC, if they could get down to 202. I think if you've even got down to 202, you've still got the same. I think it's still somewhat of a myth that you could get bright line rules with the language of of Section 202. You still have to deal with a reasonable provision. You still have to deal with, you can only bar reasonable discrimination between like services, and there's going to be a lot of questions about what's a like service, what's not a like service. You'll have questions about what is prioritization. You'll have questions, well, is it if you let a server into your ISP facility, like Netflix is doing, is that prioritization? Should that be banned? You'll have lots of ongoing questions that I think the bright line. I understand that's the rhetoric, but I think the reality will be very different even under just 202.
So, Mr. Chairman, to act in the public interest in this setting and move towards Title II and choose which sections to forbear from will please almost everyone and will displease just 4 companies. And I think that's worth considering.
Thank you. We are almost at 11:30, so we'll probably take our 10-minute break now, and we'll see you back promptly at 11:40 for our next session. Thank you very much. Hello, welcome back. We're even going to start a minute early, so I'd like credit for that, for the FCC's new and effective fast enforcement procedure. Everybody back a minute early. I'd like to shift gears a little bit in our second session here. One of the things that is proposed in the rule is the concept of ombudsman. And I say ombudsman, but obviously I mean ombudsperson. It could easily be male or female. But that the ombudsman would assist people with less resources, which we've heard about some this morning, that there is a disparity in resources between people with an interest in these questions. And the ombudsman has been proposed as being anything from someone who simply explains to you how to file a complaint, here's how the process works, all the way up through someone who essentially stands in for your lawyer and stands in for a high-powered Washington, D.C. lawyer and represents you before the commission. And so that is not something that currently exists at the FCC, and it could exist either under a 706 regime or a Title II regime. And so we'd like to get people's comments on that. Susan, would you like to start?
So I was privileged to serve on the board of ICANN, the Internet Corporation for Assigned Names and Numbers, between 2005 and 2008. And during that period, the role of ombudsman was created, maybe created right before that, but existed during that time. And so I learned quite a bit about the questions that attend creation of an ombudsman. Clear that they have to have real independence and report probably directly to the chairman and be fireable only for very limited reasons. Clear that they also, from my personal experience, need to be quite accountable for what they're producing of value to the organization, to avoid, just to make sure that they're using their time in a way that's productive for everybody. I think it's a nice to have. It's no substitute for all the other mechanisms that we're talking about here, and could actually be part of the existing consumer bureau's operations or the outreach function that the chairman's been so careful to have, that just letting people know that there's a place to complain is very important. And perhaps that's the role for the ombudsperson or the ombuds function, just outreach. So my bottom line is you need strong rules. They're really the only important thing we should focus on. Enforcement secondary to that, and then secondary again to enforcement is the role of an ombudsperson. Nice to have, not a substitute for the rest of this.
Okay. Rick?
Our position was that if they're going to have an ombudsman, it ought to be available to anybody who's a small entity who's trying to deal with the FCC. The NPRM itself seemed to indicate it was just for edge providers, but there are some edge providers who dwarf even the largest ISPs out there. So assuming that it should be available for one side and another, we didn't agree with. And then the role of the ombudsman, I guess, certainly a clearinghouse, I think could be fine, providing people information. I think the concern goes up the more they take an advocate's role. And again, it comes back to my point earlier about the Enforcement Bureau being both the prosecutor and the judge in these cases, but its role as prosecutor is really representing the American public. To the extent that an ombudsman would now represent a particular party, it starts to confuse the roles of the Enforcement Bureau. And how does the ombudsman relate to the other rest of the Enforcement Bureau? Do you have to respond to both? It becomes much more complicated and potentially problematic as you move into more of an advocacy role, I think.
I agree.
I'm sorry, Steve, did you have something?
I was just going to say, I agree with what, it might be nice to have. You have to define the role. If you're going to have it, apply it to small businesses and, just have to deal with the issues of having potentially the commission on both sides of a complaint or involved in a complaint as a prosecutor, a lawyer, as well as the ultimate decision maker.
McCall?
I would just echo what what everyone's saying, that an ombudsman is a secondary thing to consider. I think an ombudsman is only as good as the rules that he or she is helping to enforce and helping edge providers and the public to navigate. So if we were under a 706 regime and we had to go and try to prove harm to consumers and try to prove harm to competition, having an ombudsman there, someone made the analogy, it's like having a fuel-efficient car that doesn't have tires. So.
One other thing I would add, I certainly agree that if there's the commission, it's appropriate for the commission to have somebody that you can get information from about how to file a complaint and how to deal with the commission's processes. Just from almost a bureaucratic perspective, one thing I would think about is, sometimes the commission says, okay, there's a function we should have, let's create a new this or new that, and to the extent that's already something in CGB that people are doing or should be doing differently, maybe it's just a question of announcing that somebody in CGB is the point person, that if you need information about what the open internet rules are, how you can approach the commission. I talked earlier about you can go to the if you're a small edge provider, you can go to the Investigations and Hearings Division, or maybe you can file an informal complaint and get Market Disputes Resolution Division to mediate it. So if people don't know that, it makes perfect sense to have someone in CGB or something that you can say, okay, that's who will give out that information. I think as you start creating a new entity, you do start wondering, what are they doing, and does it end up just sort of confusing or complicating things in a way that is kind of unanticipated?
What I'm hearing from the panel is that the idea of an ombudsperson is generally okay. I'm also hearing some concerns about the ombudsperson being placed in the Enforcement Bureau. My question for you is, if there is an ombudsperson, who should it help? Right, I'm hearing some a position over here that some edge providers can be very, very big and can dwarf the size of ISPs. Should it help small businesses? Should it help consumers? Should it help ISPs as well as edge providers? And if it is going to help small businesses, how big is small, or how small is small? Before I'll just leave it at that. Any thoughts on who the ombudsperson should help?
Just to clarify one thing, I wasn't saying I agreed with the concept of an ombudsman. I was saying that I agree with the concept the commission should provide information to people.
Duly noted, counsel.
Let me try to unpack that a little bit, or look at the things that would feed into that rather than give a strict answer for it. And that is, what is the problem here that we're trying to solve, right? And there's a few different layers of this. The first is general awareness of the sort of rights and responsibilities of the different parties in this ecosystem, including internet users and developers and network operators as well. And the second is awareness of the steps in the procedures and the options and the possibilities available to someone who's seeking redress of a perceived harm. Right? These are separate things. I'm not sure exactly what different people feel the mix of responsibilities of an ombudsperson would be across these. But the emphasis for me is really a bit more of the former, I would say, because outreach and affirmative outreach and raising awareness that you as an internet user have rights, and we are here to protect your use of the internet and to protect your choice online, is something that is, I think, a responsibility of the Commission as a whole, particularly CGB, and something that we should be talking about more, like how to make sure people know, that you can do this. I'm not saying we should go full DTV transition in the scale of awareness raising. That was an amazing effort that the Commission put on in a very short period of time, but more in that direction, I think, would be very valuable.
Christine, I wondered if you had views in terms of consumers. Would an ombudsman be helpful?
Well, I mean, when I think about an ombudsman, it's to accept complaints from, I think it's any of the parties. I think it's consumers and industry, and then and that are criticizing maybe the FCC's performance, and for that ombudsman to make a determination of whether they're correct about it and whether the FCC should make changes. That's how I see an ombudsman. I don't have an opinion otherwise, but it's, that's it. That's really it, yeah.
Susan?
Just listening to all this, it seems to me that an outreach, even naming a person to have an outreach function is helpful to everybody, to industry, to everybody else, and also to be looking critically at the process as it's moving forward with a sense of independence. Like, does the Enforcement Bureau have enough information? Are the burdens so difficult that it takes too long? Do we need more of a shot clock? That kind of quasi-independent examination of the process would probably also be useful. And often an ombudsman serves that function.
Okay. Rick?
I would just say, just add, that the ombudsman, I think, would be available for people. I agree with the outreach function that Chris talked about. That's certainly something the FCC does all the time for all of its rules, and this would be no different. As far as the ombudsman and who it should serve, I think beyond the purpose of just helping somebody who's filing the complaint, it ought to be a little bit broader if you're going to go that direction. It ought to be help people who are smaller entities try to navigate the FCC's processes. A lot of people are not familiar with the FCC processes. That's what they were talking about before. But I think that applies equally if, a Netflix or a Facebook sues some ISP in the middle of Wyoming who has, a couple dozen employees and doesn't have anybody in Washington. They don't know how to navigate the FCC processes either. So if an ombudsman's available, it ought to be for smaller entities. How you define that? The FCC, I know, has about 10 different definitions of smaller entities, and I suggest you can pick the right one.
McCall?
I think the question isn't whom an ombudsperson should serve. I think it is the function should be to protect an open internet in the way that the FCC has envisioned in its rule. And so whoever they're helping through the process, as everyone has been saying, whether it's an edge provider, whether it's a small ISP, I imagine that the large ISPs who are probably going to be the party in the majority of the situations, and some of the larger edge providers as well, won't need as much help as the small parties. But whether through outreach, whether through helping people navigate the enforcement process, the principle that the ombudsperson should be serving is the open internet.
So I guess I have a sort of little reaction to that, which is I think the principle should be helping people understand what the Commission's rules and procedures are about the open internet, but the Commission is the decision maker, and it has a lot of processes to decide these issues, including the Enforcement Bureau that's very, can be very prosecutorial. It doesn't sound sort of right and fair to me to say that the Commission's going to say we're going to have someone that sort of puts the thumb on the scale and says our job is kind of to find violations and, that's our function. I mean, we were talking before about how the Enforcement Bureau, certainly they look for violations, and when they find them, they do something about it. But they're also sort of infused with this judicial capacity of what's the right answer and balancing are there harms to consumers? Are there countervailing harms to consumers if we interpret the law a certain way? And it's troubling to me, and the Commission historically hasn't done this, to say there's somebody here whose job is to sort of help one side. So I think that's a potential concern.
Mm-hmm. Let me change it slightly. One of the things that's in the proposed rule requires ISPs and other broadband providers to provide information to the Commission about various activities. And the standard itself talks about what is not commercially unreasonable. And in 706, and even under Title II, there's an aspect of reasonableness. So one of the suggestions for the ombudsperson or for some person at the FCC is to be the gatherer of all of these contracts, of this information, and have some assessment of what is reasonable in the sense of knowing what is going on out there. And in some ways, the FCC is the entity that has insight into across the board, the small businesses, the large businesses, and so forth. Do you think that that is a role that the FCC should play in then gathering and assessing that information, or should we leave it more to private parties? Chris?
So I have some reservations about that in the way that it was framed. I mean, certainly the FCC needs to be tracking and collecting information on the current practices in the space. But to empower one person in particular with any sort of ability to say, this is being done and therefore it is reasonable, is something that gives me a great deal of concern. I think that's the sort of decision that needs to be made much more carefully, more thoroughly, more thoughtfully, with input from engineers in particular and others, into what the FCC should consider reasonable from the perspective of its open internet rules, and not just the fact that it's being done by a lot of entities.
Susan?
Because human beings are by nature cheerful and resilient, let's think about something positive that on the transparency front that a person could ensure. ISPs make disclosures, some of them somewhere, about their practices, and often those disclosures are very difficult to find and are only available after you've already become a customer. It doesn't appear that the FCC is actually tracking that information, collecting it, aggregating it, enforcing it. So there seems to be a real function of just tapping somebody with the obligation to ensure that corporate officers are certifying compliance with their transparency obligations, that the transparency obligation is being met, that it's collected in some aggregated place so everybody can look at it. That would be a terrific function for some person inside the Commission to have.
Okay. Rick?
Responding to that, it's not true that the transparency information is hard to find. We're following the guidance set forth by the FCC. It's on people's websites and it's easily findable. There haven't been any complaints filed in the 4 years that they've been in effect. No formal complaints, certainly. As far as aggregated data at the FCC, I don't think that's a particularly good idea. It's going to be out of date pretty quickly. As soon as it's filed at the FCC, you'd have to have it would be just a lot of reporting conditions that inevitably would grow stale. And where do people look for the most up-to-date? Would they look on the website? Would they look to the FCC? I think it would cause a lot of confusion out there for no real benefit, since up till now it doesn't appear that we have any real transparency problems out there because we haven't had any real complaints.
Steve?
And I question the value of it because, at least from the WISP community, and it may be the same for others, is every network is different. And what is reasonable for one ISP or commercially reasonable for one ISP or is a reasonable network practice for one ISP may not translate to the guy who's operating the network right next door. And to sort of try to aggregate the information and draw conclusions of it that could have some value or could have some precedential value or be used against the next guy and the next guy doesn't strike me as being especially fair. I guess I'm sort of going, into the case-by-case situation, but I think, again, we can set up certain things that we know are good and certain things we know are bad. But I think the Commission in 2010 got it right when they said, if you're using unlicensed spectrum, meaning you're sharing spectrum, you're sharing infrastructure, you have, quote, unique network management challenges, and we're going to take that into account. So the problem you run into is that someone will look at what's reasonable for a big cable and want to apply it to somebody else, and that kind of fuels unnecessary disagreement.
McCall?
I think the NPRM actually specifically cites complaints about lack of transparency and how confusing it is to find the reports from ISPs, and that's precisely why they proposed a stronger transparency rule there. And I think all of us are definitely in favor of a stronger transparency rule where, as a consumer, as an edge provider, as a business, I can easily get all of the information I need from my ISP to determine whether I'm getting the level of service that's been promised to me.
So my reaction, sort of going back to a discussion we had earlier, is that the Commission should identify a problem before it starts saying we're going to do this, that, and the other thing. And we talked about having potentially someone in CGB or whatever that providing information. If people are having trouble, how do I find out what my ISP's practices are? Someone at the Commission can say, well, here you go on their website kind of thing. And if someone says it's confusing, it seems to me the Commission on a case-by-case basis looks at it and says, if they say, gee, it's confusing to us too, or we don't think it follows the rules, then that's a matter for the Enforcement Bureau to look into. But I think the concept that sort of there's somebody else out there kind of making independent judgments from that process in a vacuum, and perhaps someone who's not looking at a record and is just saying, here's what I think, here's how I'm interpreting what everyone's doing, and then putting information out about that seems somewhat troubling to me.
I just wanted, because I'm seated right in the middle of the table, I want to make common cause with Steve sitting next to me that there may be a way to draw a line between the terminating monopolies and the other players in the internet service provider market, and to say, with respect to the big guns, they should be subject to corporate certification, very strong transparency obligations, and the aggregation of that information in such a way that it's easy for consumers to find it. That doesn't seem unreasonable to me, and I would hope that my colleagues would agree with that.
Okay. I wanted to read out a question we have from the audience. The 2010 net neutrality order allowed a third party, not directly affected by a network management or business practice, to file complaints. So should the rules promulgated this year allow similar complaints from unaffected third parties? Can other people file complaints?
The only brief comment I want to make is that in the multifaceted, amazing open internet ecosystem that we have, it's hard for me to draw a clear line in my head to say that somebody is not affected by a violation of open internet rules. I mean, when innovation and competition and choice are harmed, the entire internet as an ecosystem is harmed.
I think the solution there is for them to file a declaratory ruling if they're not a party to a specific dispute that may have arisen. That would be the way to do it and to open it up to the public, as David was saying before.
But, one of the, overarching themes of a lot of the comments we've heard today, as well as in the notice of proposed rulemaking, was that consumers and startups cannot access the FCC's dispute resolution mechanisms on equal terms. And we've heard a lot of that this morning. Might the concept of a third party who's uninjured, who may just have an interest here or may have the financial backing to be able to go through the process, might that alleviate some of the concerns that the smaller businesses have about participating in any dispute resolution process at the FCC?
I would say absolutely. I think that that's precisely what allowing third parties to make complaints would do. It would benefit. I could imagine a situation where there's some nonprofit out there that acts on behalf of small startups and looks at possible violations of whatever the open internet rule might be, and that would help address the imbalance of power that's inherent in the system. And so as long as the enforcement mechanism is sufficiently thorough that you can get evidence from the parties affected and ensure that there is actually a violation happening, then I don't see why third parties wouldn't be allowed.
But usually, there's a long history of this in our legal system, and usually the advocacy group or the public interest group would have a lead plaintiff that they would help through the process, and that certainly happens in Washington too. It certainly happens in this area. So,
filing complaint, there's lots of ways to bring attention. So, I think in some ways, anybody can call up, whether it's a public interest group or it's another advocacy entity, can bring information to the Enforcement Bureau informally, very inexpensively, whether it's on behalf of consumers, on behalf of edge providers, and say, here's what we think is going on. You, Enforcement Bureau, you should look into it. And then the Enforcement Bureau can say, this seems pretty isolated or not important to us, or it can say, we've heard 3 or 4 things similar from somebody else, or this on its face looks really troubling to us, and looks into it. So I think, I guess I'm challenging the premise somewhat that it's hard to bring things to the Commission's attention. It may be that there needs to be more education so people know how to do it, but I don't think it's that hard to bring things informally, very inexpensively to the Commission's attention. And from my own practice, I have plenty of experiences where, 1 or 2 informal complaints that it took consumers, presumably just a minute to fill out, lead to, the whole power of the government coming against a company and asking for every document in the last 5 years having anything to do with this. So
we'll go Susan and then McCall.
Okay, just 2 quick suggestions. One is we're mixing some functions here. This is an administrative agency looking at a utility, right? And the idea that the reason we have a standing requirement for courts is that we don't want to get courts into the business of issuing advisory opinions. That's why it's there. This is an administrative agency. There is no need for a standing requirement that would be so rigid that would block people from bringing complaints, because we may need you to issue advisory opinions. That's the point. That's what's going on here. So that's one idea. And the next is that we want the best technical information coming in about what's happening on these networks, because they are otherwise invisible. You can see the traffic cones on the George Washington Bridge. You can't see what's happening inside these, particularly the giant players. So getting insight from other sources seems important.
Yeah, I was going to make very similar points that I don't think we should be looking to the judicial system as a model of efficiency here in the administrative context. And with respect to the ease of filing, it may be easy to file and to make a complaint to the FCC, but actually gathering the data that are involved here and making sure that there's evidence that there's been a violation is what a lot of small companies and individuals are not able to do, and that's what allowing a third person to file would address that.
Well, let me pick up on that directly related to another proposal in the rule, which relates to burden shifting. So, for instance, if a smaller party doesn't have the wherewithal to gather all the discovery and prove that there was competitive harm, should the FCC change its system such that once you make a prima facie showing, the burden shifts to the larger entity or to the ISP, which may be a smaller entity, as we're very aware of, to prove, for instance, that its actions were commercially reasonable, as opposed to making the original complainant prove that they were not commercially unreasonable. I may have too many negatives in there, but I think you know what I mean. Does anybody have any thoughts on whether burden shifting would be something we should adopt?
I have thoughts on that. Burden shifting is great, but it doesn't do very much if we're dealing with very vague standards like commercially reasonable. And if we're talking about things like harm to the consumer and harm to competition, these standards don't provide certainty, and a company like Comcast, with its hundreds of in-house telecom lawyers, will certainly be able to craft a really compelling argument that, even if the burden is on them, that this is commercially reasonable, that there is no harm to competition here, and small companies, consumers, will not be able to go up against that, even if the burden's not on them.
Chris?
I think depending on the outcome of the other rules, this becomes a different question. So if the rules establish a pretty clear standard, and if there is good transparency into network management practices to the public, it suddenly starts to make a whole lot of sense to talk about burden shifting, right? I mean, if there is enhanced transparency, and if the kind of complaint that's being filed is this disclosed network management practice, here's the company's disclosure, goes against this standard, I would hope the enforcement procedures would recognize that should not be a very thorough showing to make, right? If you're working from a disclosed practice and your assertion is this goes against this clear standard, a lot of the action then shifts, not even necessarily to the ISP, but to the commission to make an interpretive decision about whether they in fact agree or not. But that depends on a clear standard and on enhanced transparency to get that kind of information. And that goes back to McCall's points as well, that if there's a vague standard here, then suddenly it seems to make things a lot more difficult to establish that sort of prima facie case. I mean, there's the other category of potential violations and complaints as well, which is an assertion that there is some practice that is going on that is in fact violating the rules that is not part of the disclosures. And that's just a harder thing across the board. It's going to be difficult to make that case, and I don't actually know how that plays into a burden shifting, but I wanted to make sure that there's these two scenarios in mind of here is a disclosed practice. We assert that the disclosed practice on its face, according to the transparency documents, is in violation of the rules. And then the other scenario where we perceive harm as being done, but we can't point to a practice that's in the disclosures that we say is the result or the creation of that, but we still believe there is harm going on, and we need the FCC to help press and to help us find out what's going on and why there's a problem here.
I think a lot of this goes to the discretion that the FCC has. A lot of the stuff they're talking about, the FCC has the authority to do under this existing enforcement rules. With without burden shifting or anything like that sort of tries to set up some different regime. After a complaint is filed, the FCC staff is perfectly empowered and capable of ordering whatever kind of additional discovery or productions that they think are necessary, and they do. So, the legalistic shifting of the burden is not, I don't think, as important as leaving it to the FCC staff discretion whether or not to require production of certain documents, which also goes to making this, I think, a less expensive alternative to, for instance, the federal courts, where discovery is at the will of the parties and goes on and on for years. As Kickstarter, I know, is aware, and some litigation they're involved in, that the FCC is a place where discovery is targeted, but under the control of a professional staff.
We received some information last night from the Minority Media and Telecom Council, and we sent that around to the panelists. And it is also in the public record and available and part of these proceedings. But it was sent last night, but it's in effect being offered as a comment or a suggestion for today's panel, and as a question or a suggestion, as you will, from the public or from this organization. And their proposal is basically this. They suggest that the FCC adopt a process similar to what is done for Equal Employment Opportunity Commission, EEOC process for Title VII complaints. And I won't go into all the details, but I wanted to pose a couple of questions based on this to the panel. One is that they suggest that we should require informal complaints be done before formal complaints. And this would mean that if you have a concern or a complaint, you put it in to the Bureau, to the FCC first as an informal complaint. And then there can be a period of evaluation, and there can be, as has been mentioned, the FCC does mediations or other things. And then at the end, there would be some authority granted, a right to sue letter, if you will, which would say, okay, now you can go ahead and file a formal complaint if you want. And I wondered if anyone has any comments on that sort of procedure.
Yeah, I think that's a good idea. I mean, the Commission does that in some areas in certain ways where either you have to file an informal complaint or you have to first say that you've contacted the company that you're complaining about. So, for example, in some of the formal complaint rules, poll attachments and other areas, you have to certify that you've had an executive level meeting before you file a complaint. So I think things like that try to get the people together. I mean, my own experience is that when companies get informal complaints from the FCC, from CGB, the first response is to figure out a way to resolve the consumer's problem and make it go away, because companies don't want their customers to be unhappy generally, or I think always. So I think those kind of ideas are really promising, because it then lets things get resolved and leaves sort of the more serious things to the Commission's processes, which are, if there really is a dispute, whether it's a practice that a company won't change vis-a-vis consumers or vis-a-vis edge providers, you've at least given an opportunity to get it worked out.
Christine, do you have any views?
I think it's very interesting because coming from our perspective and looking at the EEOC, which is also very concerned about private enforcement and the importance of private enforcement in relation to discriminatory claims. I think it's very intriguing. And the fact that once you have this alternative dispute resolution process, and the agency gives kind of okay to go forward if private enforcement is also needed. So, which is something that we're concerned about here. So it's very intriguing.
Rick and then Chris.
As you said, we just got it last night, so I haven't really have an official reaction. But and I agree with what's been said before about some of the that it's intriguing in many ways. But I think the lead that I don't want to get lost here is that they're proposing to do this under Section 706 and not Title II. That it's a proposal for a robust enforcement regime under Section 706, which MMTC, of course, is a significant civil rights organizations, along with, I think, dozens of other civil rights organizations, including the NAACP, who have opposed Title II regulations. So I think it's certainly something that we'll take a look at.
Chris, and then Susan.
I don't have an official reaction or position on this either because it came out last night. But at this point, I feel like I'm in disagreement because an additional mandatory step before getting to full resolution will make a process that takes a long time take even longer in many situations. And especially if you go back to my last comment, let's look at the enforcement scenario of a disclosed practice, something that a company has built into their network. They're disclosing it. They're saying, we believe that this is something we need to do. This is not a situation where going to the company on Twitter or going to the company with an informal complaint is going to mean they want to change a practice that they've built into their network, that they've established that they believe they need to do to respond to consumers who are not happy with it. This is a situation where I can easily see examples where moving to a formal complaint quickly to try to get a resolution and an injunction and enjoining of this practice quickly is something that would be the right path forward. So at this point, although I have to think about it more, I'm pretty uncomfortable with adding in additional mandatory layers to this process.
Yeah, just briefly, so I'm exhausted by the exhaustion requirement. I really am, because to the extent this can be mechanical and automatic, we are talking about packets crossing transmission networks where some traffic cones may have gotten in the way and there may be some, discrimination going on in the middle. A lot of that is invisible. Let's try to make it more visible if this is the direction we want to take. But it should be automatic, complaint-driven, quick. If we're going to have a dispute, let's get the dispute done. Remember, destroying nascent businesses through a process of endless kind of jump rope through exhaustion requirements and alternative dispute resolution mechanisms is not going to be helpful to the nation's competitiveness around the globe.
I would say similarly to the Ombudsman, going to Time Warner or Comcast, one and the same soon, and complaining about the fact that we have to pay access fees to get service isn't going to do anything if the FCC has said that access fees are all right and has given its imprimatur to paid prioritization. So.
In the general administrative enforcement and litigation context, we often hear concerns about exhaustion requirements to get to court, and then once you get to court, we hear about those complaints. People say, you know what, sometimes alternative dispute resolution procedure is better than even going through litigation in the courts. Currently, parties with disputes before the Commission are free to voluntarily engage in mediation, which is offered by the Enforcement Bureau's Market Disputes Resolution Division. And one type of additional dispute resolution process contemplated in the NPRM is arbitration. Should we adopt measures to require or encourage disputes over the legality of broadband provider practices to be resolved through arbitration? What do you think about this, Christine?
I think that consumers should at all times have the option to choose how they want to resolve disputes. Of course, the FCC is building this, an ADR system, or the proposed rule has an ADR system. But in terms of arbitration, pre-dispute, just telling them that even before the dispute arises, that you have to go to arbitration. And it would likely be third-party arbitration. Who knows? Maybe it will be run by AAA or some other private arbitrator, which companies have full control over. They know how to run the third-party arbitration system. They've got it down pat. Consumers don't. Like I said in the opening statements, we've looked at forced arbitration issues in the private sector. All of our contracts have forced arbitration and prohibit consumers from banding in class actions against companies. All of them do, and including FCC-regulated companies, and to have the FCC kind of endorse that policy here would be disappointing. We've seen other agencies, federal agencies, going in the exact opposite way. Congress, in specific instances, has gone the opposite way, has banned arbitration clauses in many very critical consumer areas, like in residential mortgages, and given the SEC and the CFPB authority to ban arbitration clauses in banking contracts, checking accounts, and in investor contracts. So the FCC would be going in the exact opposite direction as its counterparts at looking at other areas that concern consumers. So, no.
I think another way to look at this is what is the remedy you're trying to achieve? Is it some private damages that you want to assess, in which case maybe the stakeholder has a specific interest in it? Is it trying to impose some sort of a monetary fine, a forfeiture that the Enforcement Bureau does under its jurisdiction? And if that's the case, then is there a need for arbitration of an individual dispute when the result is not going to redound to the specific benefit in terms of financial payment to the party filing the complaint? So I think you kind of need to say, what are we shooting towards? And there's other things that the Commission could look like. We're trying to learn about this. We want to build case by case. We want to provide more guidance to the public. And those are all very good enforcement objectives. But I think you kind of sort of say, who's going to benefit from this if there's some sort of a violation that's found? Is it the individual complainer, or is it go into the U.S. Treasury? And I think that may dictate kind of where some of these tools make sense and where they don't.
Here in our typical mediation process, we're dealing with a complaint between two businesses. It's not so much about any resolution that would lead towards lining the coffers of the United States Treasury, as it is about resolving a dispute between two market participants in a highly complex, highly regulated industry. And so I take the concerns that Christine raises about consumers, and I want to redirect the question back and say, what kinds of effective dispute resolution processes have you seen in your experience that work for consumers?
I think the issue with us and there was language in the proposed rule related to requiring arbitration. So that means before any dispute arises. So what I want to make clear is that we are not opposed to arbitration. You've heard me call it forced arbitration, and that's what the language in the proposed rule seemed to be. So it's requiring it would be a pre-dispute matter. But we do not oppose a consumer once they have, an issue with an ISB or anyone. We don't oppose them choosing it once the dispute arises. Once they decide for themselves that arbitration would be the correct route for them. So if it's an option, if it's presented as an option they could take, then that's not something that we would oppose. We just want consumers to have the option to choose which route they want to go down, which road they want to go down.
Another alternative dispute model that's been contemplated in the NPRM that some have advocated for is a multi-stakeholder approach to enforcement. I know some of you have views on that, in particular Chris, and I want to ask, can you please describe for us what a multi-stakeholder process might look like, and discuss whether it would be a good idea to adopt here? Is there a place for a multi-stakeholder process in enforcement?
Boy, do you have a few hours for me to explain?
See the clock?
Yeah.
No.
Yeah. So we included descriptions of brief references and discussions of multi-stakeholder processes in our filings in this docket, because we have experience working as part of these and with these in other policy contexts, in particular global internet governance, where multi-stakeholder has become an overused word in the views of many. The idea here, getting past the terminology, is that these are complicated issues, and many different individuals and parties and interests have a legitimate stake in being part of the discussion of what the repercussions of network management practices are, who they affect, from all sides. This is not. I'm not merely talking about one part here. And I think we've seen some experimentation into these already by the Commission, things like the BTAG, the Broadband Internet Technical Advisory Group, that has consumer organizations in it, it has edge providers in it, it has carriers in it, it has academics in it. I don't remember off the top of my head if there's government participation in it. Can somebody? Nope, I'm seeing head shaking. So it's almost got the full panoply of the traditional breakdown. But the traditional makeup of a multi-stakeholder body is getting people from the governmental sector, people from the sort of civil society or consumer sector, people from the technical business community, and people from the academic community. Technical and business communities in many instances are actually different, but that's a different context. But I don't want to get lost in the way that this term is traditionally interpreted in the international internet governance space, and instead drill down to the principle that when you're talking about the future of the internet and how individual network management practices and regulations will affect that, they're complicated issues. There are a lot of externalities involved with everything, and there are a lot of different people who have legitimate interests in being part of the conversation and raising those. And it's very important to have all of those voices be involved as part of this conversation.
So just briefly, I have some life experience with this in the ICANN context. In the realm of global internet governance, it has been very important to have multi-stakeholder processes because there what we're worried about is speech. The free flow of information and speech around the world, and multi-stakeholder functions have shielded the internet from lowest common denominator censorship of speech by other governments. That's why we have embraced this so strongly around the globe. This is entirely different. Here we're talking about the ultimate enforcement by a government of the transmission of bits, which is not speech. It's just transmission. And there you want to retain the government's hammer. You are the enforcer because we want to make sure that all the spillovers that are made possible by the internet in the United States come about and are not squelched by the sidewalks, by the carriers. A multi-stakeholder function might be appropriate in an advisory role, like tell the government what to do. But this is the government's role and should not be devolved to a multi-stakeholder process.
I'm not going to get off on the sidewalk thing again. I think these groups are very important in informing, I think, the government. I think, picking up on what Chris said, they're very broad-based. The BTAG especially has got all of the stakeholders represented. And they're driven by engineers, which I think is, if I learned anything in my career, it's the more that you empower engineers to figure things out, the better off we're all going to be. And they are a consensus-driven organization. Right now I think they're working on something about how traffic flows over the internet. And I think one important factor about how they operate is that they have a shot clock that they put on themselves. I think it's 120 days. So it goes to the speed issue. It helps. I think it's a very important part of the process given the broad-based coalition there, the people involved, and speed and consensus-driven process they have.
And I'd like to sort of give an example of where I think it could work in the process and still be consistent with Susan's concern. So let's say somebody comes to you, an individual edge provider, and says, here's what an ISP is doing, here's whatever the standard is, here's why it's, speak loosely, whatever the standard is, here's why it's unreasonable and it shouldn't be allowed. And the ISP comes back and says, here's why it's reasonable and it should be allowed. And then if you do nothing more, you've basically got people in the Enforcement Bureau, maybe policy people in other bureaus, engineers in OET, trying to figure out in a vacuum, is this reasonable or is it not? And you would be informed a lot if you went to a consensus organization like BTAG or someone with a shot clock and said, tell us what the consensus is of sort of a multi-stakeholder process. If they said, we think this is a terrible thing and it shouldn't happen, that informs you and gives you a lot more confidence that you're doing the right thing and saying, it's improper. On the other hand, if they say, this edge provider is an outlier and everybody else thinks this is perfectly reasonable, it's not a decision, but it informs you as you're thinking about your decision of what is or isn't reasonable.
If I could add just a little bit to that. So there are multi-stakeholder processes that are consensus-based and try to achieve consensus, and then there are others that are not. And when they are not, they're usually about getting different ideas and different opinions out there and getting them expressed. And I think most of the difficult scenarios that we will see in the future of the enforcement of these rules, there will not be a consensus. That doesn't mean that there isn't value for these groups as advisories, and producing a set of opinions from expert engineers. At Rick's point, I agree very strongly with. Having engineers be involved as part of this, expert engineers from a variety of stakeholder groups, can only help make the final decisions better, more well-informed, and better for the Internet.
Christine, did you have something?
Just one sentence. Just that things that are really a matter of public interest, like fundamental public interest, should be served by the agencies that serve the public interest. I don't know that it should be. There are definitely very critical issues that are as Chris said, there won't be a consent. I can tell you that forced arbitration is one of them. So we know that, and we are definitely relying on the public officials to do the right thing on behalf of the public interest.
And I want to just make a couple points for all the reasons that you've heard me today. Is one, if you do have these groups, they have to be inclusive. Second, there needs to be transparency in what they publish. And third, I always think it's better to have industry develop standards than it is to have a regulatory agency establish them. And this goes back to what was discussed on Tuesday, rules versus standards. So to the extent that any of that can come out of this, I'm all for it, but we have to have inclusion and transparency.
So we're coming to close to the end of today's roundtable. I want to make sure that I have left adequate time in case any of the commissioners or the chairman have any questions for us. I am not seeing any at this time. It is right about 12:30. We're finishing right on time. I want to say thank you to all our panelists, those from near and afar who traveled to be here with us today. Thank you to everyone who is here with us in person, as well as those who are listening in from the internet. And we are adjourned.
Thank you.
Thank you.